What's happening, IBLers? It's Mark this week, taking over for Marta to do Week 5's audio recap, or Precap, I guess. So apologies in advance for those of you who have grown accustomed to Marta's soothing and calm voice. For this week, you're stuck with me. So just to make this short and painless as possible, let's just jump right into the core or the essential aspects of CMR on international carriage of goods by road, which is the topic for your graded mock. One of the more distinguishing factors of CMR is that in accordance with Article 41 of CMR, it is a mandatory convention, just like the Hague-Visby rule was, and unlike the CISG, where parties can, in fact, opt out in accordance with Article 6. So for CMR, or for the 44 contracting states that signed on and ratified CMR, they are bound and obligated to comply with the articles of CMR, like a happy relationship. And the applicability of CMR is covered in Article 1, which essentially says that there has to be a road carriage, there's a payment, it's between two different countries, and one of those countries has to be a contracting state to the CMR. Now there's this whole bit about roll on and roll off, which is what happens in cases where a truck carrying the consignment rolls on board a vessel for a seaway, and then an incident occurs while the truck with the consignment is on board the vessel, and then something happens to the boat or the truck or the consignment where they're damaged. So it's like a turducken situation, which for those of you who don't know is a typical American dish where they stuff a chicken inside of a duck, and a duck is stuffed inside of a turkey, and they cook it all, and it's a ridiculous thing, I think, that's made in America called turducken. Anyway, roll on, roll off is kind of like a turducken, but the problem is what happens, what is the applicable law to determine the liability of the carriers? Is it CMR because the consignment is on board a truck, or is it Hague-Visby rules because it is technically on board a vessel as well? Here you would have to look at Article 2 of CMR to figure out what is the applicable law in the case of roll on, roll off. Basically, Article 2 says in case of roll on, roll off, it is CMR that is the applicable law to determine liability of the carrier. Now, there is an exception to this default rule, which is that when we're talking about roll on and roll off, the applicable law could be deemed as the Hague-Visby rule if three conditions are met. The first condition being if the loss, damage, or delay occurred during the sea carriage, so while the truck was actually on board the vessel and the vessel was on the sea, and two, the loss, damage, or delay was not caused by an act or negligence of the road carrier. So just to provide a little example, this second requirement would not be met if, hypothetically, the road carrier rolled the truck on board the vessel, and then the vessel departed the port, but then the truck driver got out of the truck and then went and stabbed the sea captain, causing the vessel to crash into a rock. In that case, the loss, damage, or delay to the consignment would be indeed caused by the act of the road carrier, so that element would not be met. It's kind of a ridiculous example, but alas. Anyway, and then the third requirement, in order for Hague-Visby rule to be the applicable law in cases of roll on and roll off, is this requirement that the loss, damage, or delay must be caused by some event which could only have occurred in the course of and by reason of the carriage by the other means. So what does this mean? It means that the damage that was caused must have been due to something that is related to the sea, right? So it was damage caused by seawater or damage caused by a big wave, a tidal wave. But if you look also at cases like thermo engineers, which is also in the reader, it's a pretty broad definition for what can constitute an event that could only occur in the course of and by reason of sea carriage. But yeah, I recommend you check out the thermo engineers case. I think very typically the memorandum contains a row case where you would have to apply and look at CMR Article 2. But for now, the good news is that the mock for Case 8 in Week 5 does not contain a roll-on, roll-off situation. So, yeah, I guess for this week you don't have to worry about it. But if you're interested in what thermo engineers is all about, or how do you deal with a case of roll-on, roll-off, maybe this would be an interesting issue to revisit after memorandum facts have been released in Week 7. But for now, let's move on to identifying some key players. Now, if you look at the case 8 for Week 5, you have a situation where you're either Culk or you're Beaker. Now, some of the questions that we answered already said, okay, well, why aren't we talking about Muppet transporters? Aren't they kind of involved as freight forwarders? Which inevitably brings us to the question of what the hell are freight forwarders? And the best way to think of them is to think of them as intermediaries, right? So they're just facilitators. And so depending on what the seller needs, they can just contact a freight forwarder, and the freight forwarder can arrange for various parts of the carriage. So if there is a road carriage and just the road carriage, it might be as simple as the sellers or the buyer contacting the road carrier directly. But what happens if there are road carriage, there's a sea carriage, there's an air carriage, and parts of it where it requires a rail carriage? Then these freight forwarding services kind of make it easier for the seller or the buyers to say, hey, you're the point of contact, you're the freight forwarders, you're the intermediary, and you are going to facilitate arranging the carriage amongst different parties involved. Now, it is true that some freight forwarders don't hire out or commission or subcontract different entities, that they have their own fleets of trucks and vessels, but very often the freight forwarders don't actually have trucks or vessels themselves. They have contractual relationships with different road carriers and sea carriers and so on. So the question of, well, who is the seller or the buyer going to sue in case there is a problem with the carriage aspect of it is usually not the freight forwarders. They usually tend to sue the actual carriers that the freight forwarders have hired. Now, this isn't always the case, but the rule of thumb is that if the freight forwarders are not actually conducting their own carriage, they don't have a fleet of trucks or vessel of boats on their own, and they are just serving as agents to the seller or the buyer, then the carrier who is liable for the loss, damage, or delay are usually not freight forwarders, but the drivers or the ship captains that have actually conducted the carriage. And so what does that mean? It means for Week 8, we're not looking at Muppets transporters at all. Now, after we've distinguished freight forwarders from actual carriers that actually conduct the carriage, the next thing that we have to kind of pay attention to is if there are multiple carriers. So, for example, in case 8, there is Beaker drivers and Gonzo drivers. Now, I've made the case a little bit easy where you definitively know which of the parties violated or breached the responsibilities covered in CMR. But if you didn't know, you would have to actually figure out, is this a case of a subcontracting or is this a case of successive carriage? And we need to determine the difference initially, because depending on which kind of carriage we are looking at, the liability regime changes. Now, if you have a principal and a subcontractor situation, that type of situation is covered under CMR Article 3, whereas if you have a successive carrier, you're looking at Article 34 of CMR. So if you go to the lecture slides, page 12 and 13, there is a graphic in terms of what the difference is between a subcontractor and a successive carrier. The case that you have for week 5 is more of a successive carriage situation where you have Beaker movers and Gonzo drivers that are successive carriage. What's an easy way to sort of deciphering between these two situations would be to look at the number of consignment notes that exist. As it says in the reader, most of the time in successive carriage, you're looking at situations where there is only one consignment note that is passed on from one successive carrier to another. I point out these details now, even though it's not really relevant for the purposes of case 8 for your mock this week. But I think as it relates potentially to some of the issues that might come back in the memorandum, I'm just kind of pointing them out here. Which kind of brings us to, and I know I'm ranting a little bit and it's not as efficient or clear as Marta, and I'm going to insert my apologies here. But let me quickly cover the issue of what are some of the obligations that a road carrier has under CMR, what are the exemptions, and what kind of a damage limitation clauses are there, which are things that are slightly more relevant for your mock case. First and foremost, before I get there, one threshold tip that I can offer you guys would be to look at the lecture slides and the to-do list on page 3, which sort of has an itemized list of things that we'll cover during the lecture. But that might also be a good frame of reference to use, because I know some of you asked whether I will post a grade sheet of sort of what Marta and I will be looking for during your mock. And the answer is no, but I think page 3 of the lecture slides that were posted, which has the quote-unquote today's to-do list, I think kind of gives a good overview of the articles that you most definitely should cover. Maybe you can stipulate whether CMR applies in the context of Article 1, but then it starts talking about, okay, what are the carrier's liabilities and duties under 17 subparagraph 1 and 3? What are the exemptions of liability, specifically under 17 subparagraph 2 and subparagraph 4? And then it also discusses the relevant burden of proof in accordance with 18 subparagraph 1, subparagraph 2, and subparagraph 4. And then it talks about sort of the limitations of carrier's compensation amount in Article 23. Also throws in Article 24 and 29 about willful misconduct. So my tip for you would be to sort of look at that and then use that as a guide to sort of say, okay, these are some of the key articles that we should discuss during the mock. And as I suggested during the tutorials, I think it's a good idea for the two parties to set a clear agenda to discuss what the main issues would be during the 1 hour of your graded mock. So, starting with the main duty covered under 17.1, obviously the carrier is liable for the loss, damage, or delay that occurs between the time it takes over the goods to the time of delivery. Now, from 17 subparagraph 1 to 17 subparagraph 3, the road carrier obviously has the duty to provide a vehicle that is free of defect. Now, 17 subparagraph 3 is related to 17 subparagraph 2, because in order for a road carrier to use or to rely on exemptions covered under 17 subparagraph 2, there must not be a breach of 17 subparagraph 3, which means that the vehicle was free of defect. Now, what's a little bit different about CMR is that it offers different kinds of exemptions which are covered in 17 subparagraph 2 and 17 subparagraph 4. Now, the question is, why do they have to separate it? Oh, hey, I'm getting a phone call. Hold on one second. Hello?
What's up, dude?
I'm trying to record something. Can I call you back?
Yeah, sure.
Okay. You want to say hi to the IBL people?
Hi, IBL people.
Okay. All right. Bye. Sorry about that. So the difference between 17.2 and 17.4 and why CMR divides having two different exemption clauses has to do with the burden of proof. So this is where you have to read Article 17 in conjunction with Article 18, which talks about the burden of proof. So if a carrier is attempting to rely on the exemptions covered under 17.2, not only must they first establish that there was no breach of 17 subparagraph 3, but in addition, the burden of proof is on the carrier in accordance with 18 subparagraph 1. Whereas the carrier is attempting to rely on exemptions covered under 17 subparagraph 4, then it's actually on the claimant in accordance with 18 subparagraph 2, the claimant that has the burden of proof to show that the damage wasn't actually caused by the risk, the special risk listed under 17 subparagraph 4. Now, as you are probably well aware by now, there is one exception to the burden of proof being on the claimant for any 17 subparagraph 4 related exemptions, which is 17 subparagraph 4 subparagraph D, which is about the nature of the goods within the consignment. So if the goods are susceptible to natural decay, rust, leakage, these kinds of things, then Article 18.4, 18 subparagraph 4, actually says that the burden of proof actually goes back to the carrier, and the carrier would have to actually prove that they've complied with all the claimant's special instructions to the extent that they were given specific instructions. So my last tip regarding the issue of 17 and 18 for the purposes of the mock is for both parties to be very clear about what you're talking about. Are you talking about 17.2 or are you talking about 17 subparagraph 4? And depending on which article, which exemption you're talking about, make sure that both parties are aware of which party has the burden of proof on this issue. Okay, so that covers 17 and 18, and I know I'm kind of ranting on, so apologies. I know Marta is a little bit more precise and efficient and doesn't say too much like I do, which is very annoying. But alas, let me talk about damage in the context of the 25 and Article 30, how you can sort of circumvent the damage limitations through 24, 26, or 29, and then wrap this up. Now, because Case 8 for Week 5 focuses on damage, so the mahi-mahi has diminished its value from first class to second class. So we're looking at 25 subparagraph 1, which says the carrier shall be liable for the amount by which the goods have diminished in value. But to the extent that the fish, the mahi-mahi, is still edible, still resellable, there should be some discussions in terms of what the exact amount of damage is, if you guys have time for it. Does the fact that the value of the mahi-mahi was stated within the context of Article 24 make any difference? Is that the maximum amount of damage that they can claim? Or if Kulk is interested in seeking reputational damage and something above and beyond what was stated in Article 24, how can they do so? One particular way that might be relevant would be to look at Article 29 and to discuss whether there is indeed a willful misconduct on behalf of Beaker. You can look at the facts. Is the fact that Beaker's driver stepped out to have lunch in Munich enough to constitute willful misconduct? Is the fact that he only tried to fix it by duct tape? These are some of the things that you can discuss. I won't get into too much detail about it. But the relevant rule, because the seat of arbitration is in Germany, would be to look at this question of whether or not there is indeed a willful misconduct or not, bearing in mind that Germany uses a more objective, reasonable person standard. So the question for deciding whether there is indeed a willful misconduct in the context of CMR Article 29 depends on what a reasonable person ought to have done in the same situation as the Beaker driver. Again, this is the one jurisdiction which is objective, but then I have not provided any case for. So if you would like to research some German case law on what constitutes willful misconduct, this is also an opportunity for where the groups can actually show that they've conducted additional research to differentiate yourself in one way or the other. So that's basically week 5. Sorry, this precap lasted a little bit longer than usual. Marta will be back next week, which I'm sure you guys are very happy to hear. I'm sorry I also took a phone call in the middle. How very unprofessional of me. But that's just me. So, anyways, if you have any questions about recording or substantive matters, you know how to reach us. Looking forward to a fun week 5. Okay. See you for the lecture then. And I'm sorry about all the uhs.